Well, good afternoon. My name is Mike Leonard, and I serve as the co-chair of the International Affairs Forum. And before we begin, please take this opportunity to silence your cell phones if you have not done so already. This program is brought to us courtesy of a grant from the Grand Traverse Band of Ottawa and Chippewa Indians. The drum circle, yeah. Our International Affairs Forum addresses international issues, and we have an international presence in our backyard that we seldom acknowledge or appreciate. We are going to address it today, the history and ongoing presence of the Anishinaabe people in our region, the Ottawa, Ojibwa, and the Potawatomi. We recognize that the land where Grand Traverse, Leelanau, and Antrim counties are situated is the ancestral and contemporary territory of the Anishinaabe people. Today, represented by the Grand Traverse Band of Ottawa and Chippewa Indians and the Little Traverse Bay Bands of Ottawa Indians, we honor the Anishinaabe peoples as the traditional stewards of this land and water and acknowledge the enduring relationship between them and their traditional territories. Miigwech. And at this point, I would like to ask Chairman David Arroyo of the Grand Traverse Band of Ottawa and Chippewa Indians to come to the stage and say some words of welcome, and they will be followed by an opening ceremony by the drum circle, Dusty Bear. Chairman?
Miigwech, Mr. Leonard. Can we get a round of applause for Mr. Leonard? David Arroyo, Indigenous Cause, Egomawid Dao, Anishinaabe, Kachawikwadong, Meanwhile, Ani Ganabid Gite Ode, Miigwech, Kinigabijayig, Meanwhile, Miigwech, Gamikuwang. Hello, everyone. My name is David Arroyo. I'm the tribal chairman for the Grand Traverse Band. My Anishinaabe Noswin, my Anishinaabe name is Looking Forward to Old Heart. And I want to thank you all for being here. And I think I said thank you for the invite, but I'm not too sure. If there's any fluents out there, might have said the wrong thing. I might have said thank you for, anyway. So anyway, I just want to also say miigwech to Mark Wilson. He's a former tribal counselor, and at times he's a really good friend until he asked me to say a welcome to events. Then the friendship slips a little bit. But we met at a 2% event, Mr. Leonard and Mr. Alex Tank, and it was great. We had a brief conversation, and it's good to know that there are organizations like this that are willing to take the time to set up this type of opportunity to have an engagement. You're in for a treat today. Matthew Fletcher is a GTB tribal member, and I will say this, I'm not gonna repeat myself, but Matt is smarter than he looks. Sorry, I'm so sorry. When I have a microphone and I know they can't say anything, but it is not very smart to say something about somebody that they come up after you, so let's just we'll call it a draw, Matthew. But anyway, just as my experience being on council, an elected official for the Grand Traverse Band for a number of years, when you look at tribal sovereignty, there's a complex relationship we have with the federal government and other entities, whether it be state or local municipalities. But the tribal sovereignty can be a complex and in-depth arrangement. Many times, I think it's really helpful if you have willing parties on both sides to have that engagement. I know many times, I don't want to get off topic, but one thing we've experienced, depending on the administration, I can't remember who was president before Biden, but we had difficulties with that administration. Thank you, miigwech, thank you. And then in the 2000s with George Bush, we had many issues. And I think when you really look at what there is, if there is something that may be unfamiliar or unknown, then there's an opportunity to come together and create a partnership and develop or create laws that will help ease the burden of whatever that may be. But it's really helpful if you have engaging parties who are going to uphold the bond or contract that may exist, like with the treaties. I know that the federal government does have a trust responsibility to work with tribes, and many times that is either eroded or overlooked. But I believe Matt will give a great, in-depth, insightful not just overview, but explanation of tribal sovereignty. And I'm not too sure if he made it here today and he was opposed to me saying this, but John Petoskey is the general counsel for the Grand Traverse Band. He is a great resource too. As a matter of fact, I told him I was going to make a motion to put him on stage with Fletcher, and he said, don't do that. He said, don't even mention my name. How dare you? But I'm just kidding. I'm glad somebody laughed at that. But before we begin, this group of singers, it's really good if you're unaware that whenever you see a drum group, they should be referred to as singers. And I'd like to take the opportunity to introduce these gentlemen because they do have a wealth of knowledge, and I respect and admire these guys because they have, I don't know if this is an accurate way to say this, but they have hundreds of songs in the data bank of their minds, and to me, it's intimidating. I learned how to sing about a year ago. I guess I should say I'm still learning how to sing. So if you hear somebody off beat, it's probably me or the shorter guy over there wearing the ankle bracelet, the monitor. But anyway, so I'd like to introduce Tom Showman. He's a former council member. Tom worked for the tribal government for over 30 years, and he's got a ton of experience. I consider Tom a mentor. He's a good guy. He's very helpful. I'm learning a lot about our culture and our ways, and Tom's one of the guys who I learned from. And the other gentleman is Fred Rayfield. Fred Rayfield is a tribal artist. He's been singing and dancing for most of his life. Then we have Paulie Rayfield with his back to the stage. He's been singing for years. Aaron Chivas is our current language department manager for language and culture. Very knowledgeable individual. He too is smarter than he looks, if you were wondering. I'm just kidding. These guys are good guys. We joke all the time. But anyway, if you're able to, at some point, he would be a great person to have as a resource. I know I had a conversation, I believe, with Miss Shane earlier, and if you're able to, Aaron would be the guy to connect with regarding any type of connection. Good person. And then the last person is Lakota Rayfield. He's a game warden for us. And anyway, at this time, we'll have the song. Miigwech. So that was a test. I'm glad they passed it. Jacob Broom's a good guy. He's been singing for a long time, too. So sorry for doing that. It's just these lights. It's pretty bright in here. But anyway, Miigwech. And at this time, we will do the opening song.
Thank you again, Dusty Bear, and we'll be hearing them one more time at the conclusion of this event. So thank you very much for, singers are great. I'd like to introduce our onstage personas here today. Our moderator is our own IAF board member, Mark Wilson. Mark is an audiovisual producer and owner of the New Leonard Media here in Traverse City. He is an enrolled citizen of the Grand Traverse Band of Ottawa and Chippewa Indians, where he served as the vice chair of the Tribal Council until 2022. He has also served as the chairman of the Natural Resource and Environmental Committee and trustee for the Great Lakes Fishery Trust. Mark currently serves as a city commissioner in Traverse City and is the mayor pro tem of this terrific community. Mark engages in international research and water protection, collaborating with Indigenous nations from Canada, the United States, and New Zealand. Our speaker today is Matthew Fletcher. Matthew is an internationally recognized expert on Indigenous law. He is the Harry Burns Hutchins Professor of Law at the University of Michigan Law School. He teaches and writes in the areas of federal Indian law, American Indian tribal law, Anishinaabe legal and political philosophy, constitutional law, federal courts, and legal ethics. He also sits as the Chief Justice of the Pokagon Band of Pottawatomi Indians, the Poarch Band of Creek Indians, and the Grand Traverse Band of Ottawa and Chippewa Indians. He also sits as the appellate judge for the Cabazon Band of Mission Indians, the Colorado River Indian tribes, the Hoopa Tribe Valley, the lower Elwha Klallam tribe, the Mashpee Wampanoag tribe, the Match-E-Be-Nash-She-Wish band of Pottawatomi Indians, the Nottawaseppi Huron band of Pottawatomi Indians, the Rincon band of Luiseño Indians, the Santee Sioux tribe of Nebraska, and the Tulalip tribes. He is a member of our Grand Traverse Band here. He previously taught at the Michigan State University College of Law, 2006 to 2022, and the University of North Dakota School of Law, 2004 to 2006. He has been a visiting professor at the law schools at the University of Arizona, the University of California, Hastings, the University of Michigan, the University of Montana, and Stanford University. He is a frequent instructor at the Pre-Law Summer Institute for American Indian Students. Matthew has a truly impressive CV of academic work, as well as acting as staff attorney and consultant for a list of tribes, too numerous to mention here, but well worth checking out at the U of M website. So please give both our moderator and our speaker a warm welcome for what is to be a very informative event.
Buju Kenegwea, Mangan Indigenous Ottawa, Anishinaabe and Dow, Mang Dodam. My mother named me Mark Wilson. Mark is actually a family name, and it derives from my grandmother was Elsie Mark, and her grandfather was Niwagijik, and when he was baptized by the church, his name then became Peter Mark. And if I'm not mistaken, Matthew is also a descendant of Peter Mark, so I'm very honored to be up here with a relative of mine of that's held in such high esteem. And then two more things. I just want to apologize for David. You give him a microphone, he thinks it's open mic, and a comedy club. He's ran for council so many times that it's really hard for him to turn off the constant campaign, and so he's got that vibe. But he does deserve a big round of applause, because this is one of his last events presenting as our tribal chair, as there will be a transfer in leadership tomorrow during the swearing-in ceremony. So thank you for 20 years of service to Chairman David Arroyo. So, second thing before we begin, do you want to correct any mispronunciations that General Leonard may have stumbled through? But I was very impressed and proud as he was reading that massive list that I've heard you say before, embarrassing long CV. He actually omitted a lot of info.
It was a worthy effort.
So we'll dive right in, and I can't see the audience, so I'm not going to ask for a show of hands or who have heard of a treaty, who has an understanding of a treaty, but maybe we'll just start real small and then grow to the international aspect of tribal sovereignty.
Sounds good.
So to you, can you explain what the treaty is where on the land where we stand right now and sit?
So we are on lands that were ceded by primarily Michigan Odawa Native people in 1836. We call the 1836 Treaty of Washington. It was negotiated by about 3 dozen Anishinaabe people from northwest lower Michigan, who are mostly Ottawa, a few Ojibwe, and some upper peninsula Ojibwe as well. And that 1/3 of the entire landmass of the state, what is now the state of Michigan, was sold by the tribes back in those days to the United States government. And there's a reason why the state of Michigan was initiated into the United States in 1837. In order to complete the statehood process, they had to extinguish Indian title to the lower peninsula, and ultimately the half of the upper peninsula as well. So that is a treaty, one of approaching 400 total treaties between the United States and Indian tribes in the United States, and not the only treaty that the tribal communities here in Michigan or in this area signed, but probably the most important one. And it was an acknowledgement, an explicit acknowledgement that the United States was entering into a treaty with a government, a sovereign entity known as an Indian tribe. And we call it Indian tribes as lawyers because the Constitution says Indian tribes. It lists Indian tribes as sovereigns right next to states and foreign nations in something called the Commerce Clause, which I won't try to bore you too much with. But the fact that it's there indicates that the founders of the United States acknowledged Indian tribes as governing entities with sovereign powers. And that's sort of the legal background for that, and the historical background for that is international law.
Now, I've read your book. The Eagle Returns came out in 2012. It's a great insight into how these titles came to change hands between tribal members and non-tribal members. Can you do just like a brief overview of that?
Yeah, that's a class I teach in law school called Federal Indian Law. So the way the United States works, especially after basically all the lands outside of the original 13 colonies, which were lands ceded by tribal nations to other governments, primarily the United Kingdom, is this, that Indian tribes are located living on their own lands, and the United States gave that ownership a legal term, which was a legal fiction. It was fake. It's called Indian title, sometimes called original title. And what that title is just another word for land ownership. What that did was it allowed the United States to take exclusive power to buy lands from Indian tribes. So that's the extinguishment or the termination of Indian title was a requirement for the United States to expand. So the first step was to go to tribal nations and talk them through selling their lands. Now, you might wonder why anybody in their right mind would sell anything to the United States government. There were problems that tribal nations were facing at that time. Number one is an influx of settlers, colonizers, into their communities that would create an enormous amount of difficulty for everybody involved. This was the very beginning of the United States was going back to George Washington, Thomas Jefferson. They knew how to deal in Indian affairs. They had a plan. The plan was to find basically poor people from the 13 colonies and shove them west. And the ones that died, if they all died, send a bunch more. The whole idea was to create conflict, was to create war. And so the only opportunity for the United States at that point, they would weaken tribal nations. The Americans, the ostensible Americans who were the colonizers who were sent into Indian country would be clamoring for help. And eventually, there may be a war, there may be some sort of conflict, or likely here in the state of Michigan, they just wore us down. And the 1836 treaty was an unusual treaty in that we weren't really worn down for the most part. We lived in northern Michigan, which you cannot invade. It'd be like invading Russia. It's cold up here. It's swampy. So either you freeze to death if you invade northern Michigan, or you end up with malaria and all die for that reason. So that was something that the United States couldn't do. So they had to talk us into it. And actually, they kind of tricked us. We had a guy that was our lead treaty negotiator, one of my favorite people in history. I call him the Boba Fett of Michigan Indian tribes because he was truly a badass. His name was Eshkwaganabe. And the Michigan Ottawa communities, which includes, now we would say, Grand Traverse Band, Little Traverse, Little River Band of Ottawa Indians, Grand River Ottawas, Burt Lake or Sheboygan Band, possibly others, all hired effectively, appointed Eshkwaganabe to be the lead treaty negotiator. So like I said, 36 guys went to Washington, D.C. Mostly treaties were not negotiated in D.C. They were negotiated in the homelands of the tribes, but we went. Henry Schoolcraft talked us into it, coerced us into sending people. They met Lewis Cass, they met Andrew Jackson, and Eshkwaganabe negotiated a treaty for the lower peninsula Michigan Ottawas. And at the conclusion of the negotiations, we sold all our land. We didn't intend to, but Schoolcraft tricked us. And to his, you think some people are smart and diabolical at the same time? Well, that's Henry Schoolcraft. He said, look, we're going to do a treaty here. You're going to sell all your land except for some reservations we're going to create for you. And if you don't, I brought a bunch of my relatives up from the Upper Peninsula who aren't a part of this treaty negotiation, the Ojibways, and they'll sign the treaty. And when I go to the Senate, they won't care who signed it, as long as a bunch of X's are on there and a bunch of Indians signed it. And it's going to be a valid treaty whether you agree to it or not. And that was pretty much the end of the treaty negotiation. But out of that treaty, the fact that we were considered nations that could enter into a treaty is an acknowledgement by the United States of sovereignty, an acknowledgement that has never gone away. It still remains, for purposes of the United States, we are still sovereign governmental entities and have been at least since 1836, if not before. That's a big one. We also had Article 13, which is our treaty, off-reservation hunting and fishing rights. So in addition to the lands that were reserved for us, for the tribal members that purchase lands, tribal nations that purchase lands, we have control of those lands, but we also have the right to hunt and fish off the reservation on lands that remain unsettled, effectively. And that's most of northern Michigan. I mean, you might say, look, there's a lot of people up here, but not really that many. So that's a robust thing that the tribes here are still exercising. After the extinguishment of Indian title, we acquired reservation lands. And that process is an incredibly complicated process. In other contexts around the U.S., especially out west, you can still see those reservation boundaries. Not so much here in the United States, because Henry Schoolcraft just didn't create the reservations like he was supposed to. He had no intention of doing so, because he was not a very good person. And so eventually there would be another treaty in 1855 that we alluded to, and we can talk more about that. But that's the process. You start with Indians living on their own lands. You enter into a treaty with them. Indians sell their lands. Reservations are often created, but not always. Sometimes Indian people are forced to remove to the west, and tribes here in northern Michigan are lucky enough to avoid that problem.
Very well done. Now, suppose that treaty didn't happen and we went back. Would this land have become Canada eventually? Or would we have said, you know?
That's an interesting question. Michigan is in the United States because of, ironically, the War of 1812, a war that the United States lost. Don't ever let anybody tell you the United States won or even tied the War of 1812. I don't know if you know this, but they burned the United States Capitol to the ground. That's a pretty good sign you lost that war. But the U.S.-Canada border came out of that war, and Michigan is in the United States as a consequence of that. Now that war ended in 1814, and it was probably a good 10 years before anybody around here saw an American. And so, as a practical matter, for probably decades, at least even after the 1836 treaty, the state of Michigan, or at least the northern part of the Lower Peninsula, was pretty much Canada, was pretty much a British territory. And so tribal nations around this area would go to Canada, Manitoulin Island, or in other places in Lake Huron or in Lake Superior, and meet with British diplomats and military leaders, and they would give us what we call presents. They would give us stuff, because of course we would go meet them. There are buddies. There are second colonizers, the French being the first, British being the second, and the Chumukman being, the Americans being the third.
So what are the impacts today of the treaty, and then when we look at, since it's right here, the U.S.-Canadian border, and say Ottawa's on both sides of the border?
Yeah, that is a huge, huge issue. So 1830s, when Andrew Jackson was the president of the United States, was a period that we call the removal era. And that's when the Cherokee Trail of Tears happened. That's where, many, if not the vast majority of tribal nations and east of the Mississippi River were forcibly removed to the west. That's why there's 38 Indian tribes in Oklahoma instead of about 5 or 6, or dozens in Kansas and Iowa. Tribes that are really from the Great Lakes area are all over in that area. We were able to avoid that for the most part, but it was a period of time when it was unclear whether the U.S. was going to come in through Andrew Jackson and his successors to force us out. And a lot of people left. And I'm a descendant of Leopold Pokagon, who is the namesake for the Pokagon band of Potawatomi Indians in southwest Michigan. They were a really good example of what happened. Leopold Pokagon was able to negotiate a situation where he was able to, for his community, he was able to avoid being removed, but most of the Potawatomi communities were removed. That's why you have the Citizen Band Potawatomi in Oklahoma and the Prairie Band Potawatomi, Kansas, and even the Hannahville and Forest County Potawatomi communities in northern Michigan and northern Wisconsin were originally removed, and they figured out a way to get back. But all of that was a consequence, or created a lot of movement, migration amongst Anishinaabe people. A lot of people went to Canada. When I was a young man, or young boy, so we're talking like the 70s, my family used to pretty regularly go to Walpole Island, which is near Detroit, north of Detroit, on the Detroit River, and there's a Anishinaabe community there, and there were originally Anishinaabe people there, and then a whole bunch of people moved in the 19th century. So there are all these people in Canada, and Garden River, north of Sault Ste. Marie, for example, is another Ojibwe community that probably was formed, at least in part, by basically refugees from the United States. So there are thousands of descendants of people who went through that process, who left the United States and went into Canada to stay with relatives. Canada wasn't in the business at that moment of removal. The United States was. And so that was for many people, that was a safe place to go. Consequences of that are they're Canadians now. Effectively, they're citizens of Canada. And the United States recognizes, under precepts of international law, the principle of the duty of protection, or also known as the trust responsibility to Indian tribes. The United States does not recognize a trust duty to Canadian First Nations. They do not. Those are our relatives. Many of them have treaty rights in this state or in the Great Lakes area. They're likely descendants of treaties from the 18-teens, 1820s, 1830s, including the 1836 treaty. They have rights under those treaties, but due to historical situations, migration, being forced out, they don't have access to those rights. And that's something that I find personally aggravating. It's a real tragedy in a lot of respects.
With that said, with talking about recognizing and the trust responsibility, can you, just for the audience sake, explain what a tribe is and then how that relates to a band and how we have individual bands with individual sovereign rights?
Well, that's a tough question. This is like asking, I always say, if you ask 100 Indians who an Indian is, you're going to get 100 different answers. So you're going to get a bunch of different answers about what an Indian tribe is. Let me go back to Eshkwaganabe. Eshkwaganabe was from around here. He was from the Eastern Shore over in Antrim County. I think I'm related to him too. His nephew was a guy named Agosa, who lived on Old Mission Peninsula over at where the mission is. And those two guys and another dude from Leelanau County were the Grand Traverse Band contingent that went to Washington in 1836. Now, Eshkwaganabe was the head of a village. He was mostly his relatives, people that married into his tribe. He was the guy. He was what we would call an Ogama. So he was the leader, ostensibly, of basically a family or a kinship community. Same with Agosa across the bay, the East Bay anyway. And then there were about 20-some in Leelanau County and Grand Traverse around the Boardman that the third guy, whose name I can never pronounce or remember, represented. These were all individual nations. So nobody could tell Eshkwaganabe what to do. There was no chairman of the Grand Traverse Band to tell Eshkwaganabe, you've got to come along with me. That's a tribal, effectively is a nation. Same with Agosa's community. And all of a couple dozen more villages around here were all sort of separate and independent. Now we had commonalities, regional commonalities, language group commonalities, alliances effectively, we're all related, to bring us together as sort of the Grand Traverse Band. We were banded together, like a rubber band in some respects. And now we call that an Indian tribe because the Constitution says Indian tribes, and all the federal laws relating to Indian affairs reference Indian tribes. I usually now say tribal nations, but I mean, they're all sort of misnomers for this thing that it really is a governmental entity. So that's kind of how a tribe can form. Like I said, all of these bands in the Grand Traverse region came together early in 1836 to decide who was going to go, if anybody, to D.C., Washington, D.C., for this treaty negotiation. They selected these three people to be their representatives, and Eshkwaganabe ultimately as the leader of that community. And later on, all of the Michigan, Ottawa tribal nations came together separately with our three representatives from here, and they met as a different council, quite possibly at Green Sky Hill near Sheboygan, the Council of Trees. And from that community, they selected a speaker who ultimately was Eshkwaganabe as well. And there were others from Little Traverse and Little River and other tribal communities. And across Lake Michigan, across the straits, were the Ojibways who came down. We can talk about them too, but they were not particularly relevant initially to that meeting in 1836. But that's really what a tribe is. It's a government. And I will say this, the ironic thing, the biggest probably the irony of federal Indian law is that the United States never, until just in the last half century, ever treated tribal nations as sovereign governments. They never really did. The irony is the Constitution itself, they wrote our sovereignty into their Constitution. And so even though we're in their Constitution, listed next to other kinds of sovereigns, for basically until the 1970s, they treated us like children, like subhumans. And that notion of Indian title I gave you, that only applies to people who don't have legal rights. That's the reason they thought they could get away with that. And they did, until fairly recently,
So how does the border here between Canada and the United States and the bands here, how does that differ or similar to the Southwest tribes that border, say, Mexico?
Well, I like to think of Anishinaabe Key, that's our lands of the Anishinaabe, as basically running all the up and down the St. Lawrence River and the Great Lakes tributaries, everything. That's all Anishinaabe territory. So there's a reason why Canada's capital is called Ottawa. It's because of us. It's because we got on canoes and we dominated. We used the river system, the lake system. We dominated the political and economic everything of this area, this whole region, all the way to what is now the capital of Canada, all the way over in Ottawa, because we had the best canoes. We literally had the best canoes in the world at that time. They're still the best canoes in the world. Jimana. And that's how we were able to control this area. So the Ottawas, we're known as the traders, with a D, not the ones who betray people. So that was we were sort of in charge of the trade routes, and so through really well into probably the 1850s, that this whole area was under the control of Anishinaabe people, primarily Ottawas. The Upper Peninsula was primarily Ojibwe. The lower half, sort of south of Grand Rapids, was primarily Potawatomi or Potawatomi. Everything else was Ottawa for the most part. And when you get to Detroit, that's a totally different group of tribal nations, and another Ottawa group down there as well. So if you look at the South, it's at least we have some, here. You can say that there are geographic justifications, I guess you could say, for the border. Even though Ottawas are definitely on both sides of the borders, Ojibways are definitely on both sides of the borders. But if you go southwest, the line is just through the desert. It's completely arbitrary. And so you cut tribal nations completely in half. Most notably, the Tohono Nation, which is in Arizona, has a very large reservation in Arizona that is really only half of their total land base. The rest of it is in Sonora, Mexico. And they really struggle with being able to communicate with each other, to be able to provide, the government's providing services to tribal citizens on the Mexico side. You've got border patrols going back and forth. There are conflicts, and it's incredibly difficult down there. And I would say probably worse off down there in part because of the racism of the American immigration policy. Brown people do not do well in the American Southwest, unfortunately.
I had a conversation with Frank. Frank Edewagijic is a highly respected tribal elder from our area, and this wasn't on my list of questions that I was given, but I think I want to bring it up. Is he was talking about when we think of like other countries besides the U.S. and Canada, Mexico, when indigenous nations are fearful to even say the word sovereign. And that word holds a lot of weight and could get them killed. How does that differ here to where we're, brave enough to assert our sovereignty? What does that mean? What's the difference? Sometimes, like during my time on tribal council, people would bring up ideas of like, can't we have our own shipping port? Can't we do importing and exporting off of our tribal lands? What is the limitations of that, and why is it capped?
Yeah. Well, a couple of things. You have a lot of questions there. The big one for me is, I think it is my understanding, I could be wrong on this, that the United States is the only colonizer nation that recognizes sovereignty within indigenous peoples. And again, they wrote it into their own constitution, so they're stuck with it, whether they like it or not. Canada, for example, they have stuff in their constitution about recognizing treaty rights, but they do not recognize the sovereignty of the First Nations in Canada. And let me give you an example. I haven't spent a lot of time working with Canadian First Nations, but I did work with a company, Haudenosaunee company out of Ontario years and years ago. And I asked them a few questions about their governmental entity, and they basically said, we don't really have one because Canada will come after us. And so, for example, let me give you an example. I had four jobs before I was a law professor, working in-house as an in-house attorney for 4 different tribes. And every single one of those tribes asked me to write an animal control ordinance. And I did, and they all rejected it because indigenous peoples do not like putting chains on dogs. So I respect that. I asked them about animal control ordinances in First Nations in Canada, and they said we would have to get the premier of each province to approve even a simple animal control ordinance. They don't even have that power. It's fully federalized, and it's insane. They're moving forward in some respects there, but not very, very slowly, and really frustrating. So in some respects, we have it good, in that at least in the last half century, since the 1970s, the federal government formally has acknowledged that tribal nations are governments in the U.S., that we have inherent sovereign powers, and we're exercising those powers in ways that my grandparents would never have predicted. I mean, it's an amazing circumstance. But outside of the U.S., it is a totally different world. If you're in New Zealand, Australia, and Canada, you're lucky to have governments that won't execute you for asserting your treaty rights or rights to land or culture or rights to your children. But in other places, it is definitely a very scary, scary place to be. And so I'll leave it at that.
Check the time here, because I know we want to save time for Q&A.
One more question, Mark.
Yeah.
Okay, I'll tell you what I'll do here. We'll turn the lights up so that we can see everybody's smiling face. And but I'm going to start with as we're collecting up the questions. Matthew, if you were rewriting the treaties that of 1836, what do you think should have gone in there that didn't go in?
Oh, a lot.
A lot.
Our treaties are very short. 1836 treaty is just a few pages long. And there's an enormous amount in that treaty that is unspoken. And I liken it to the dark matter of physics. You guys ever heard of the notion of dark matter? So scientists believe that there is X amount of matter in the universe, but we can only see about 25%, maybe 50%. We know it's there because there's gravity to it. We just can't see it. We call it dark matter. No explanation for it. The treaties have dark matter too. It's called the duty of protection. So in 1836, when we sold to the United States the landmass of 1/3 of the state of Michigan, that landmass had on it old growth timber, the white pine, all the trees that you can imagine. And the United States, once they began to assume control over the territory, it took a few decades, like the 1870s really, that's when they started cutting all the trees down. All of the state of Michigan was deforested, all of it, except for 2 small cosps of trees, one in the lower peninsula, one in the upper peninsula. They cut the whole thing down. You can imagine what the value of those trees is in today's dollars. I'm going to say trillions. It is an ungodly amount of money and resources. You know how much money we got for the lands we sold? It was 10.5 cents an acre. And that's not very much. And then in the late 90s, we reached an agreement with the U.S., a settlement on additional money, but even that was like an additional $15 million. So it wasn't very valuable to us as a dollar figure. So the United States got a little bit more out of it than we did, let's say that. What the difference is between the U.S.'s value that they acquired in this land and what we got, that's the dark matter. That's the duty of protection. That's the reason the United States must fund healthcare and housing and law enforcement and job training and education. They promised to do so. It is contained within the treaty when it says a tribal nation comes under the protection of the United States. That is a legal term of art from an international customary law that says the United States owes an enormous amount to tribal nations that entered into these treaties. And we don't even know the full scope of that. So if anybody ever asks you, like, if the United States says in a given year they spend $1 billion on Indian health, that's a pittance compared to the actual value that the United States owes to tribal nations around the country. And that's just the beginning.
Well, thank you, Matthew. We have another question here, and this is probably the subject for an entire seminar, but for those who have not been raised either in an indigenous culture or associated with it, what is the difference between recognizing and celebrating the indigenous culture and actually being guilty of cultural appropriation? Are there rules that the non-indigenous cultures should know and follow to avoid creating some form of offense?
Dang. I feel like if I answered that question conclusively, it would just give people a roadmap on how to take our culture again. That's a great question, and it's a really important one. And my answer, the lawyerly answer in me is you have to talk to tribal nations, elected officials. They all have a cultural affairs department. It might be a museum, it might be something else, it might be elders. Go through the tribal government itself, the elected representatives, and find out what their rules are. I don't know what their rules are. That's where you have to go. There are American rules too, you know, so the last thing I'll say is a good friend of mine who is Potawatomi from Oklahoma, teaches at UCLA Law School. Her name is Angela Riley, has a paper coming out in the next year or so where she and her friends, her colleagues, counted all of the trademarks that exist in the United States that have something to do with Indians. So you'll see like Navajo trucking go by or something like that, anything with an Indian name in it. 95% of those trademarks are owned by non-Indians. And it's almost like it's too late. But it is a really important question. And there's a lot of work to be done in that, and I'll leave it at that.
Thank you, Matthew. We have an online question from Janae from the Leelanau Conservancy, and she asks, can you help us understand the allotments and what happened to tribal ownership of allotment lands?
So now we have to ask if John Petoskey is here. Not because I can't answer the question, but I want to see his face while I answer it. Is he here? Hey, John. Thank you. All right. So I'm sure you get asked this a lot. So in 1855, because the 1836 reservations were not perfected, we had another treaty, and additional reservation lands were set aside for Grand Traverse Band. They were different lands. There's a map. This is what the lands would look like from the 1855 treaty. The 1836 treaty wouldn't include much from Leelanau. It would include Old Mission Peninsula primarily and some on the eastern shore. So we moved to a different territory effectively in 1855. But in 1855, instead of Henry Schoolcraft, we had a guy named George Manypenny, and he liked allotments. And allotments were where you take a chunk of reservation land that in 1836, it would have been owned by the tribal government in common. So one owner, it's the tribe. And they can do anything they want with it. And for purposes of American law, that was the situation. That's reservation land. In 1855, the United States said, what we really want to do is we'll set aside these lands, and then tribal members, heads of household, can select a parcel of land individually. So it's not the whole tribe owning the land, it's individual tribal citizens owning the land. So tribal members would be given a period of time where they could go within the reservation, pick up a stick and mark an area, and go to Traverse City and put it on a piece of paper that this is their selection. That's called an allotment. The first step in an allotment is a selection. Tribal members would get a certificate saying that they have selected an allotment. Now, the way the law worked under the treaty and the way allotment works is that land for the first 25 years was owned by the United States. That's trust land, a trust allotment. And then at the conclusion of the 25-year period, the trust allotment would be turned into a patent. So a patent is just another way of saying the first of something. So that would be the tribal member who had an allotment after 25 years, would own that property in what lawyers call in fee. It would still be an allotment, but it would be a fee allotment instead of a trust allotment. Now, most tribal members who made selections at Grand Traverse Band and Little Traverse and Little River went to Traverse City or wherever their federal land office was and made the selections. And on the federal land office side, there's a lot of incompetence, there's a lot of corruption. On the other side, when an Indian person would make a selection and then they would leave for a little while, a couple of weeks, maybe to go fishing, maybe to go to the beach and do some swimming, or go collect berries, or do some sugar bush, or wild ricing, or anything that people do when they're living, where they leave their home, that's when people would come and say, oh, this Indian has abandoned his allotment. And they would take the claim and go down to Traverse City and say, we're taking over John Petoskey's claim, and it's ours now. And guess what? The general land office in Traverse City would be like, sounds good to us. So that's how we would lose our land. Other people lost it through coercion, tax foreclosures. Trust land's not supposed to be taxed. That didn't stop the counties. They would just put a tax foreclosure on it and sell it underneath you. That's what effectively happened at Burt Lake, if you ever heard of the burnout. So that's what an allotment is. In theory, an allotment, once it is perfected, will be held in fee by tribal citizens forever. I mean, after it's a fee allotment, you have to pay taxes on it, but it's still part of the reservation. It's still Indian lands, and for purposes of federal jurisdiction and superintendency, it's still Indian country. And the reality is, most Indian people never got to the point where they were even able to select an allotment, or if they did, it didn't get perfected at all. So the United States made a promise in 1855 that they would set this land aside for us. They didn't complete that promise. They still owe us this land. Now, you guys probably know this. Other people live on this land. It's not like the United States can just go and kick everybody out and say, everybody on Lake Leelanau, you got to go. This is all Grand Traverse Band land. Nobody in 2024 is really seriously making that claim. I'll make that claim because I'm a law professor. I can say anything I want. But what the tribe is really demanding at this point is an act of Congress allowing the tribe to sue the United States. Here's a weird thing about sovereignty. Federal sovereignty is the king can do no wrong. So you can't actually sue the United States without Congress giving you permission to do so. And that's pretty weird. That's not democracy at all, but set that aside. So we're asking, Grand Traverse Band is asking Congress to give us permission to sue the federal government to get a payment, basically for a taking of our property interest under the Fifth Amendment of the Constitution for the failure to perfect all these allotments. And that's sort of where we are in 2024.
It's ironic that, how many of those households in that green area today leave all winter long.
Now, I said there's one big irony, but all the rest of it is ironic too. We're supposed to have Northport up there. You can see Northport's cut off. That's because when, in 1855, the treaty went to the Senate for ratification. The way treaties work in the United States is the president negotiates a treaty, and only the Senate has to ratify it. There was a senator who had some land up there, and he's like, keep Northport out of it. So they just cut Northport out. So there you go.
Oh, man.
Matthew, could you please explain why the 1836 treaty tribes had to negotiate two separate consent decrees affirming treaty rights for Great Lakes fishing and inland hunting, fishing, and gathering?
Sure. The Article 13 of the treaty, the 1836 treaty, says that Indians stipulate to the right of hunting and fishing on the ceded territory, so off reservation, until the lands are required for settlement. Now, in 1973, Native American Rights Fund and the United States brought a lawsuit on behalf of, back then it was just the Bay Mills Indian community in the Upper Peninsula, against the state of Michigan, called United States versus Michigan. And that was a treaty rights claim to the Great Lakes. So until the lands are required for settlement, as the treaty says, it doesn't say anything about waters. And so the United States was asserting control over fishing on Lake Michigan, Lake Superior, and Lake Huron, and asserting control over treaty fishers, and that was illegal. And that's why the United States brought a lawsuit. Now, keep in mind, they'd been doing it for like almost a century by the 1970s, so it took the United States a long time to get their shit together, but they finally did. Just as an aside, you know the state of Michigan has the first state to create a Department of Natural Resources or something like that within the state. And the state of Michigan's mythology, origin story about that is, well, we just love our game and our natural resources so much we wanted to protect and manage them. They created it to persecute Indian people from exercising their treaty rights. That was the reason for the creation of the DNR. We call it EAGLE now, which is ironic, but we'll move on from that. Yeah, the reason that there are two is there's one for the lakes, and then when I was working at Grand Traverse Band with John Batoski back in 2001 to 2004, what was happening was that inland, on the inland rivers and streams, there was fishing going on. There was hunting on state, federal, and private property. That was all, potentially, is all a treaty protected hunting and fishing. And so that was just sort of one of those things that was just kind of out there, and we needed to conclude it. And a Republican Attorney General of the state of Michigan reopened US v. Michigan to settle all of that. And as a practical matter, that's why we needed a second consent decree. Now that one was done in 2007 or so. It's done. We don't ever have to go back to that one. The lakes consent decree is one that typically expires after 15 or 20 years, and we have to constantly renegotiate, and now we are litigating over that. So 100% employment for Indian lawyers.
I think these two questions may be related, so you can either answer both of them or either if you like. Matthew, you've referenced the 1970s as the time when sovereignty began to be honored. And, this questioner wants to know if you can speak to that as to why that occurred in the 70s. And the other question is from Eleanor Lynn, who, by the way, she is an attorney. Can you explain Public Law 280 to the audience and how that impacted tribal sovereignty?
Yep, I can do that. So, but I'm gonna, on the first question, why into the 1970s, I would say this, really, it was supposed to happen in the 1930s. In 1934, Congress passed the Indian Reorganization Act. Again, that was during the Great Depression. That was the first, as far as I can tell, the first federal statute that was designed to actually assist tribal nations in some respects. Every other law, even treaties, were designed to ease tribal nations into oblivion or just wipe them out. This 1934 Act was the first time that was kind of reversed. And it didn't go anywhere because the Great Depression, there wasn't much money, and then World War II happened, and then we had after World War II, we had the Red Scare, and we think of that as being anti-communist, but it was also very anti-Indian. And so Congress in the 50s moved forward with an attempt to terminate tribal nations. And it wasn't until the 70s, as a consequence of work by the Kennedy and Johnson administrations, and Nixon's administration took credit for it, but whatever. That's when Congress, and that was actually the Ford administration that ushered in the first of the Indian self-determination statutes. And that's sort of the world we live in now, where Congress appropriates money, goes to the Bureau of Indian Affairs or the Indian Health Service or another federal agency that administers an Indian Affairs program, and some or all of that money can then be just shifted to the tribal nation, which would then operate tribal governmental activities on their own. So that's why I say the 1970s. But for Michigan tribes, the Michigan Ottawa tribes and the Lower Peninsula, the Michigan Potawatomi tribes in the Lower Peninsula, there's 6 of them, we didn't get the benefit of either the 1934 Act or the 1975 Act because the United States terminated us we call it administrative termination, but really what it was is the Secretary of the Interior stopped returning our calls illegally. And so we're some of the few tribes in the United States that actually had that happen to us. And so Grand Traverse Band in 1980 was the first tribe administratively restored effectively to federal acknowledgement. And the other tribes followed in 1994, in 97, and 98. So now there are 7 tribes in the Lower Peninsula that were not federally acknowledged as of the 80s and 90s. And that's really when tribal sovereignty for Lower Peninsula Michigan tribes began.
Thank you. This is the last question we have, and since we're surrounded by the magnificent waters of the Great Lakes and the interior waters, this questioner asks, how much power do the sovereign nations have regarding water protection?
Not as much as they should. So the treaties create or recognize property rights to these lands and to these waters. And that's a thing that is usually glossed over, is that tribal nations are property rights owners. And we have a property right that we can distribute to our tribal citizens to go fish on the lakes or the inland streams and lakes. We have a property right that allows tribal nations to distribute the right to hunt, to fish on lands within the ceded territories. And as a practical matter, that means federal and state public lands and within the 1836 treaty ceded area. So within the exercise of those rights, the tribes have pretty robust powers. The Constitution does not allow the states to interfere with Indian affairs. That's federal laws. And so there's something in the Constitution called the Supremacy Clause, says the states can't mess with that. And the federal government, at least since, again, the 70s, has been leaving, for the most part, tribes the opportunity to govern those activities. But it does raise the question, what if the state or the federal government or private entities, private actors, start polluting the water or polluting the lands or denying access to the property interests that the tribal nations have? And that is a real question. And we really don't know what that is. Now, in Washington State, they had these things called culverts. I don't even know much about Washington. It's very mountainous. They have anadromous fish that they rely upon, tribal nations do. It's salmon, steelhead, stuff like that. It goes out into the ocean, comes back up. The culverts were destroying all of the streams that would allow the fish to come back and spawn. And so the tribes sued the state of Washington as part of their lawsuit, U.S. v. Washington, and saying that the state has an obligation and does not have the right to destroy the habitat of their anadromous fish. Now, we have the same argument here. The state of Michigan, the federal government, allowed a pipeline company, for example, to put a pipeline under the straits, under the water on top of the Straits of Mackinac. And they didn't ask our permission. This is the 1950s, 1940s, before the tribes were federally restored and before the United States was adopting a self-determination type policy. They just did it. And there was nothing that tribal nations could do to stop it. Probably didn't even know about it for the most part. And there absolutely is a property right in the tribes who are the 1836 treaty signatories to have clean, pristine waters. We need that for everything. It is everything that we are. And it's not just because we eat fish. It's because this is our religion. This is our culture. It's everything about us. It's our economy. It's our law. And so that's what I mean. Like, we have some, but not enough. And the nice thing about tribal nations, and the reason that I loved to work for them and continue to try to advocate for them, is because they're really the only ones out there that are consistently helping humanity and protecting the environment for our purposes and restoring the proper role that humans play in this universe, in Anishinaabe key. We're not supposed to be dominant over the world, over the universe. We have a role to play that is much more humble. You know, if you think of how we organize ourselves socially and governmentally, we belong to clans. So I'm Bear Clan, I'm Makwa Dodam. And that's like and from my perspective as a law professor, it's like that's a political party. But there's Loon Clan, there's Crane Clan, there's Eagle Clan, Turtle Clan, all sorts of great clans. And these are the entities, the things, the creatures that we aspire to be like. They're superior to us in a lot of respects. The great things about humans are we have superpowers. We have the power of imagination, we have the power of free will, self-determination, I guess you could say. But our goal, our obligation to the universe is one of harmony. We're sort of supposed to be the glue, to help be the glue. And I don't know how many elders have said over the years, if humans are dominant, then something is really, really wrong. And just look around you.
Thank you, Matthew. I was going to ask you for concluding remarks, and I'm still going to offer that opportunity, but I really can't think of a better summary than the one you've just provided. Thank you. However, you are both welcome to say anything you like at the end here before we thank you again.
I learned a lot. And as I said at the top, I'll say it again, it was an honor to sit and have a conversation with you today. Miigwech, everyone.
And I would like to personally extend a thank you to Matthew Fletcher and to Mark Wilson. Mark, in particular, you've been a great friend and a great guide here, and your help to the International Affairs Forum as a board member has been incalculable. So thank you from a personal standpoint. I really appreciate it. I thank all of you for your participation, and to our for the day's event, thank you for all of you that came out and helped me chip away at my mountain of ignorance. Miigwech. And at this time, I'd like to ask the drum circle to come forward again, please, and that will be the conclusion of our program. Thank you.